do the...
It's my pleasure to welcome legal expert Mr. Vinod Sampath for the second time in a Money Life Foundation event. We are deeply thankful to him for giving us his valuable time. Mr. Sampath is a prolific writer and has authored many articles on property-related matters and has written 46 books on various subjects, all allied subjects like cooperative societies, transfer of flats, recovery of dues, registration and stamp duty matters. He is an advisor to the Federation of Accommodation Industry in India, an advisor to the Maharashtra Chamber of Housing Industry, apart from being part of many, many committees. He was amongst the first persons to oppose the compulsory registration of flats being introduced by the Cooperative Department. He had pointed out many irregularities in the Bombay Stamp Act in 1958, and the authorities have rectified many of them given his suggestions. May I now please request Mr. Vinod Sampath to come and make his presentation.
Sucheta Dalal, her team members of Money Life Foundation, my friend Pankaj Kapoor, other dignitaries of the dais and friends. I am going to share with you my views on a purported bill which is 100% in favor of builders. Perhaps it is an exaggeration to say it is not 100% but 200% in favor of builders. I will explain to you the intricacies of the same. Have you ever wondered that since 1963, Maharashtra Ownership Flats Act being introduced, what has been the impact on the flat purchasers? It has always remained a toothless act, and now it will be without a single tooth. The only thing that was feared by the builders was criminal action and the consumer forum. Criminal action is now out, and so is consumer forum. Any person to carry out any activity requires funds. With a merger budget of approximately 1.25 crores, what do you expect the real estate regulatory authority to do all over Maharashtra? We all know that no one wants to give premises to government department. I will read out the fund allocation. Financial memorandum. The bill proposes to repeal the Maharashtra Ownership Flats Act and proposes to establish competent authorities, Housing Regulatory Authority and the Housing Appellate Tribunal, for ensuring effective implementation of the law. Very noble intention. The competent authorities are already working under the existing act, and therefore there is no additional recurring or non-recurring expenditure from the consolidated fund of state on this count. For establishing the Housing Regulatory Authority and the Housing Appellate Tribunal, recurring expenditure of rupees 1.36 crores and a non-recurring expenditure of rupees 1.24 crores will be involved. The expenditure is only for 5 years from the date of establishment of the Housing Regulatory Authority and the Housing Appellate Tribunal, and thereafter the expenditure for the Housing Regulatory Authority and the Housing Appellate Tribunal will be borne from the collection of revenue of the registration fee, penalty, etc. What is 1.25 crores? I ask each one of you. Can you even get a flat for 1.25 in some decent locality in Bombay? And this is, mind you, the budget for the whole state of Maharashtra. Not to mention the expenses of salaries, the infrastructure, the number of offices they will have in 1.25 crores. So you can guess how much will be allocated for the city of Mumbai. how much will be the allocation for the staff. As we know, practically every political party has got builders at the helm of the affairs, and they have left no stones unturned to ensure that this bill becomes toothless from its very inception. Admittedly, cash is substantially involved in real estate transactions is known to one and all. Corrective measures were taken in the nature of 37I so that black money component could be reduced. Well, if income tax department felt there was no need of 37I, what do you expect from state government departments? Any wrong thing being done by the builder and there is no criminal liability. Basic thing is the plan should be approved. Without even approval of plans, builder will present a rosy picture like his prospectus. How will a common man know? If supposing I am a common man, I look at the government website, I see beautiful brochure, attractive photos of building. I will be under the impression all is well. And what is well, that time will only show. I had heard a lecture on MOFA from one of the High Court judges, and categorically he stated that the problem with the drafting persons in Mantralaya is they ensure that the drafting is so poor that countless number of man hours of the court are spent only on interpretation. Let me read out the preamble of the MOFA Act. Whereas the Maharashtra Ownership Flats Regulation of the Promotion of Construction, Sale, Management and Transfer Act 63, though enacted to provide for relief to flat purchasers against sundry abuses, malpractice and difficulties related to construction, sale, management and transfer of flat, it is noticed by the state government that the said act did not provide for an effective implementation arm for its various statutory provisions, as the flat purchasers could only approach consumer forum or civil courts for acts of omission or commission regarding the provisions of the said act. This is being drafted by the intelligent persons who are supposed to be experts on Maharashtra Ownership Flats Act. Any Tom, Dick and Harry is well aware of the fact that scores and scores, countless cases are pending against the builders in the Metropolitan Magistrates Courts, Sessions Courts and even High Courts. And are they having, see the guts of this? They say that only action is being taken in civil courts and consumer courts. Is action not being taken in Metropolitan Magistrates Court? Are they not aware of these things? In fact, select committee was supposed to do the job in a better manner. What proposals were there? And see what they are writing in the preamble. Apart from this, the preamble mentioned civil courts for acts of omission or commission of provisions of the act. And whereas establishing a housing regulatory authority and an housing appellate tribunal will ensure effective implementation of the act. This is what was the original preamble. And when it comes to the new preamble drafted by our select committee, very conveniently they remove the sentence, and an housing regulatory authority and a housing appellate tribunal will ensure effective implementation of the act. They themselves are confident that this particular object is not likely to be achieved. That's why they remove this thing in spite of the fact that it is these very people, their political parties who have drafted this. When we start looking at the definitions, let's take the definition of carpet area. One can simply define carpet area, what can be measured inside the premises. And what they do, section 2D, carpet area means the net usable floors area within a flat or building in accordance with shall have the same meaning as assigned to it in the relevant development control regulations. In Maharashtra, there are so many cities. In Maharashtra, how many development control rules are applicable? Whether it is for Bombay, different. It is for different in Thana. And for other areas also it may be different. Why can't they define a simple thing in a simple manner and eliminate competition and corruption? When you go to BMC, for X sort of thing, there is a different method of calculation. And for Y sort of things, carpet area. Section 2SR proposes to give blanket right to the builder to sell car parking. There are scores of Supreme Court judgments that when a flat purchaser is purchasing a flat, he is paying money not for the four corners of the flat, but for the undivided right, title and interest in the common areas and amenities appurtenant to the premises. I ask a question. We had MOFA. Say, by next year, this MOFA will go and the regulatory authority will come. And tomorrow a question is asked to the regulatory authority. I am a flat purchaser of 95. What is the position of car parking? I am a flat purchaser of 2012. What is the right of the builder on car parking? Won't it lead to conflict, confusion, complications? Same authority, different span of time, different laws, and interpretation will have to be there. What was the need to favor builders and give them money to be collected from the flat purchasers? Supreme Court is very clear, builder cannot sell car parking. As a flat purchaser, when I purchase a flat, I am paying money not for the four corners of the flat, but I am paying certain amount for the undivided right, title and interest in the common areas and amenities appurtenant to the premises. This particular aspect, why they have introduced is nothing but to favor the builder. If I am rich, I will purchase 50 cars and keep it. Won't it amount to discrimination? Is there any law which says that a builder cannot sell 50 cars to an individual purchaser in the new flat? There is no such law. Won't it lead to more jealousy? What object is being achieved by allowing a scarce space like car parking to be utilized by a rich person? If there is a society, one can utilize it that first in, first out, or first in which car has come, any person can come and park the vehicle. There can be some uniform rules. If I am a rich person, I will purchase 10 parking. Nothing is mentioned in this MOFA for the same, which according to me is a very serious issue, and definitely it is going to create lot and lots of problems. Rich will dominate, there is no doubt about it. Now, a very tempting and all this, you have to register, blah, 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 things are there. I am a builder. I take black component on day one. I put one of my unknown person as a marketing executive of mine. Though the deal will be done through an estate agent, I will say that I as a builder, I don't recognize that estate agent. You do whatever you want. I have not appointed him. And we know how market scenarios are working. Can a single flat purchaser even insist for one clause in the agreement? Agreement is a printed document prepared by practically every developer, and one has to sign on dotted lines on that thing. You will find in MOFA, in the new regulatory act, everywhere as per the terms and conditions of the agreement. But who will have a say in the agreement except the builder? No one else. Section 4, subclause 10, subclause 3 makes a mention about getting occupation certificate. Well, the job of the builder is not just to get occupation certificate, and they are using the word occupation certificate or building completion certificate. Promoter has to convey the title, and the title is conveyed only when the property card is transferred in the name of the legal entity, and no steps are mentioned anywhere in this particular whole of act. When is the property card likely to be transferred? Nothing is being mentioned about the building completion certificate. No element of accountability is being mentioned as regards builder's responsibility to get the building completion certificate. The only good thing in the whole of the act done by the select committee is section 5 subclause 2, which stipulates that also in a very vague language. 5 subclause 2, I'll read out the precise thing so that we can get it. No promoter shall start any transaction including sale or marketing for sale of flats in a new project or phase of such project without displaying such flats on the website of the Housing Regulatory Authority. Good. Provided that projects that are ongoing as on the date of the commencement of the section and where the occupation certificate is still to be obtained, the promoter shall make application to the regulatory authority. No promoter, 5 subclause 2, which is important. No promoter shall start sale of a prescribed percentage of flats the area of which shall not exceed 10%. It can be 1%. Loophole. The word is sale. I am a developer. 10% restriction is supposed to be kept for me. I cannot go till I obtain occupation certificate. Now as a developer, I will sublet that flat for a long lease. I am within law. I have not sold my flat. I am getting all the income from that flat. So I am not a loser. 10% they are saying you cannot do it till the occupation certificate is received. But in this particular manner, I will create a long thing. And definitely when there is a live-in license or a lease, no one can stop me. So the very purpose for which this particular section is being introduced is ensured that it dies a natural death. Section 11, clause number 1. Today builders are taking money at even 3%, 36% interest. Here, as a builder, he will take some amount in cash. A flat purchaser will come with any fighting spirit. Builder will say very calmly, go and do whatever you want with the regulatory authority. As and when regulatory authority will pass an order, maybe after 5 years, 6 years, 7 years, I will pay you your money with 15%. And if you have got some friends, please bring him. I will give him 18% interest. Who is going to get money in such 15% increase? All said and done. Inflation, we know it is touching double digit. When inflation is so much, what is the sense of 15%? There is no accountability on the builder. He can literally dominate the market in all ways he wants. And the worst thing is, he will say, you do whatever you want, I will pay you 15% and I go scot-free. Section 11 subclause 4 stipulates, responsibility is cast on the flat purchasers not to do any additions, alterations. I ask all the people sitting here, is their flat as per rules and regulations? Have they not encroached the niche? Have they not encroached the drying space? Have they not put a water tank in front of the flat? Have you not put an additional door in front of your door? If you are purchasing 2 flats, are you not going to demolish the common wall between the 2 flats? Are some of you not going to shift the position of WC? Are some of you not going to shift the position of the kitchen? Are some of you not going to change the elevation of the balcony? Are some of you not going to put the box grills and try to utilize those areas? So the builder is given a lever to attack you rather than you attacking the builder. What has he got to do the moment the flat is sold by him? Here a lever is provided to the builder from day one itself, that if you try to act smart against me, I can also screw you up. And this is where Mofa, any Tom, Dick and Harry, he can file a complaint. Because if you look in terms of probability, out of 50 flats in the building, definitely 30 or 40 flats in the building, according to me, will definitely have done these changes. Section 12 talks about accounts to be given. Now let us look at section 12. The promoter shall maintain building-wise separate account in any bank or sums taken by him from persons intending to take or who have taken flats deposit, including any sums so taken towards the share capital formation of cooperative society company, outgoings, municipal taxes, etc., and shall hold the said money for the purpose of which they are given, and shall disburse the money for those purposes, and shall on demand in writing by an officer appointed by general or special order by the state government for the purpose make full and true disclosure of all transactions in respect of that account. Government officer, we know in whose lap he is always sitting. And this disclosure will be made by the promoter, not to the flat purchaser, but to that government officer. That too, when a state government orders or something is issued. So where will the flat purchaser get justice in this? Basically, the flat purchaser should have a right to inspect all these things and get copies of this. Where is the provision about the flat purchaser getting records from the builder? It says you go get an order from the state government, and you know how state government works. Section 13, there is difference between conveying the property and getting the property card transferred. I will do certain things, but unless the property card comes in my name, it has got no legal value for a cooperative society. On that particular aspect, I will come in the subsequent sections. Today, the law is such that if I am constructing, there's a cluster of buildings. My building is number 1. Builder cannot use my FSI. He cannot load the TDR on the neighboring plot without my consent. And because of that, the flat purchasers, the cooperative society have got a good amount of control. By taking blanket permission in the name of layouts, this right of the flat purchasers, of the legal entity cooperative society, is also snatched. Section 15 is slightly good because the defect liability period is increased from 3 years to 5 years. That is certainly a good thing, but the impact of it is not that much because we are seeing a transformation of Bombay and we are seeing many multi-story builders constructing multi-story towers. So they definitely care for quality and definitely this 5 years period is good. Penalty, as we mentioned under section 16, to refund the amount of 15% interest. But what about VAT, service tax, income tax, stamp duty, registration, works contract tax? All these taxes, there is no mention that builder will pay you back. You know, once you pay money to the government, do you expect that money to come back to you? And all these are also not small amounts. Visualize the situation that today a builder has taken some amount of percentage in cash. He has got various clauses in the agreement which are in his favor. When such is the situation, do you think any prudent person will think of fighting a builder when substantial amount has already been taken in cash? If you go and fight the builder, the only thing you may get is with 15% after how many months, years or decades, that's for you to guess. Time and again, there is no mention of building completion certificate, which is basically the most important document. The drafting is done in such a way everywhere the wordings that are used are occupation certificate or building completion certificate. The persons who are drafting the municipal laws have specifically enacted building completion certificate because it's common sense that a file, if occupation certificate is received, whether it is part, the file remains at the same place, the same office, the same building proposal department. Only when the building completion certificate is received, the file is closed, lock, stock and barrel and sent to the godowns. Nowhere in this particular thing, enforcement is there and insistence for only building completion certificate you will not find anywhere. Section 18(1) stipulates of the various amounts that are being collected. Now builder, if I am a builder, a flat is sold from A to B, I will collect certain amounts initially. That topic is also, for reasons best known, not touched. Section 18(2), let us see that. 18(2), where a cooperative society or a company or any other legal entity of persons taking the flats in a layout consisting of more than one building or wings is to be constituted, the promoter shall form separate and independent cooperative society or company or any other legal entity in respect of buildings or wings. The promoter shall submit application for formation of cooperative society or company or any other legal entity in respect of each of the building or wing as prescribed. Very good, very nicely we are mentioning that for each wing we will form a society. But what happens in reality? When there is, say, a construction of 5 buildings or 6 buildings, or whatever it may be, each of the wings or a building will have separate societies. There are various common areas. And you know from your experience, space is a scarce commodity. Today, I foresee a situation if the entry is one, there are common areas are there. If I am not having parking, someone will throw nails and try to puncture the vehicles. Someone will park vehicles in the common passage. So all these things are going to lead to bones of contentions and disputes originating. And each society will be fighting one against the other, and the builder will be like a very calm person enjoying that tamasha. Instead of forming everyone together, at this stage itself, multiple outlets for fights are being created. It is very, very difficult to have small societies and maintain it. What about the common expenses? A building on the main road says we don't want a watchman. The building on the main road will say, I don't want lights because I am facing the main road, I am getting light. But the building at the fag end wants all these things. So all these will be all bones of contentions which are unnecessarily being involved in this particular act. Rather than solving a problem, are we complicating the things more or not? That has to be decided. And here also they are saying about layout. If a small society is there or multiple societies are there, you will get conveyance for only the structure of the building and not the common areas. Section 18, subclause 5 talks about competent authority for forming the cooperative society. But what is there about the statutory obligations that are cast on the builder? He has to obtain the property card. He has to get the title first transferred in his name. Is any steps taken by builders to get the title of the property in his name? If the government was so serious, they did not have to do anything, just 3 or 4 simple corrections like their earlier title has first to be in his name. 25% of the property cannot be sold unless the conveyance is given. Building completion certificate is given. Second project IOD will be given only after the earlier project's conveyance is executed after 2 years. Whatever constructions are there, in 2 years if he doesn't execute the conveyance, he will not get any further permission. If these 2-3 simple things are there and a record is maintained of the IODs being sanctioned, the date he is applying, he is getting period of 3 years for constructing the building. Why is it that after 3 years he is not able to execute the conveyance or complete the construction? Pankaj just now mentioned that 5 years, 6 years normally it takes for an average building, and that also if the building is a big one, it can take more than 7 to 8 years also. What is the control being kept by the regulatory authority that he does not misuse the IOD and applies for extension of the IOD? Not a single word. Today, there are scores and scores of bills not paid by the builder. Ultimately, the municipal department also earns money there because they are supplying water to you on a humanitarian grounds. And what is this humanitarian grounds? They charge double the amount. They forfeit your security deposit. Is this humanitarian grounds? What is the difference between a gunda and the government who mints money in this particular manner, solely benefiting the builders, because the builder was supposed to take all these things and the government authority should have directed their vent against the innocent, instead of the innocent purchasers, it should have vented it against the builder. Why are they not blacklisting the builders and filing FIR? If MOFA provided for making this non-cognizable offense into cognizable offense, 99% of the problems will automatically get eliminated. Now see the intelligent drafting, section 19, subclause 2. Remember, in property laws, for the whole of India, Transfer of Property Act is a supreme act. Under this Transfer of Property Act being a central act, quite a few states are there, they are having Individual States Act, which is much below the Transfer of Property Act. And even if in Transfer of Property Act any Tom, Dick and Harry writes anything, it does not take away the right of any court. Now see the drafting. Section 19, subclause 2. In the case of layout, the said conveyance shall till such time as the entire development of the layout is completed be only in respect of the structure of the building, in which the minimum number of 60%, etc. The conveyance shall be subjected to so and so. Now it starts the fun. Provided that, notwithstanding anything contained in this act, or in any agreement, or in any judgment, or order of the court, or in any other law, for the time being in force, the promoter shall be entitled to develop and continue to develop the remaining layout land with the right to use the internal access roads and all facilities, amenities. I am not able to digest. Is the representative of the builder drafting this particular law superior to a court order, superior to a decree of the court? and all the laws collected anywhere in the world pertaining to property. And what is the so importance about this regulatory bill? That it can supersede the provisions of a court order or a court decree. How can one have the guts to draft such type of things, notwithstanding anything contained to the contrary? And what has the select committee members done when they read this particular thing? Is common sense, I ask every one of you, does it appeal to you that court order has got no value? What is the meaning of court? If a bureaucrat by writing notwithstanding in any order of the court, can he take the court for granted? Then what will a common man do? Court is the only savior of the common where injustice has been done. And here they want to include such things. And sadly our politician friends are supporting them.